Hello, my name is Thorne Barasa, the president of the ICJ in GLUNS, and our class today shall be how cases are brought before the ICJ. So we've looked into the functions of the court, we've looked into how the court works, we've looked into where the law comes in, we've looked into what warrants a case to come before the ICJ, and we've said that the ICJ decides cases where one state wrongs another state or one state violates a treaty. So how do these cases come before the court? And I mean, for a dispute to be heard before the court, it has to be properly brought before the court in accordance with its rules of procedure. And that is what marks the transition from it just being a disagreement to it being a legal dispute. And preliminarily, bringing a case before the ICJ involves one state not formally notifying the court that a legal dispute exists and it requests the court to resolve it. But as we've discussed before in our class for jurisdiction, that is only possible if the court satisfies itself that it has the legal authority to listen to this, and it also depends on the consent of both parties that they can be before the court. So the courts have seen they have jurisdiction. Both parties have consented. Who can bring a case? As we talked about this before, the ICJ is not a human rights court, and it is only states that may be parties before the court in a contentious matter. This means individuals, corporations, NGOs cannot initiate proceedings before the court. So this rule reflects primarily the nature of international law, primarily governing relations between sovereign states. So where individuals are affected by international disputes, their claims must be brought indirectly through their state. So say I am affected by something that has happened to me by a policy from another state violating my own state. I cannot go to court. I will ask my state to table my case before the ICJ. And there are two main ways where the courts or other cases may be brought before the court as set out in the ICJ statute. So first we have the special agreement or the compromis. This is both states jointly agree to submit a dispute before the court. They define the subject of the dispute and accept the court's jurisdiction in advance. Meaning, this state has wronged this other state, and one party feels aggrieved, one party feels like they need that day in court. They agree, and they, through the special agreement, they agree to submit the dispute before the court, and they accept the court's jurisdiction in advance. And it is the most straightforward, and it avoids dispute over jurisdiction. And in MUN, mostly it's the preferred method because it allows delegates to focus on substantive legal arguments rather than procedural objections. But the special agreement or the compromise is when both states agree to submit the case before the court, and not only that, but also they accept the court's jurisdiction way beforehand. But there's also the unilateral application, and here, one state, which is the applicant state is the state that is bringing the case before the court, files proceedings or files an application instituting proceedings against another state, the state that has done something wrong, which is now called the respondent state. And the application must include the identity of the parties, the subject of the dispute, and the legal grounds for jurisdiction for this application. Once the application is filed, the court notifies the respondent state, which then has the opportunity to either accept the court's jurisdiction or challenge the court's jurisdiction. So this normally leads to the preliminary objections we discussed before, mostly used by the respondents. And the difference between the special agreement and the unilateral application is special agreement, both states agree to submit the issue before the court and accept the jurisdiction. Unilateral application is the applicant state files an application identifying the parties, identifying the subject of the dispute and the jurisdiction of the court within its application, and filing it. And then the court notified the respondent that, hey, this other state has filed this application against you. You have the option of accepting the jurisdiction or not, and so by that they can do that by way of preliminary objection. And well, we've talked about the application a bit, so let's go into a bit more detail. And a properly filed application, especially when a state decides to go through unilateral application, is very important, and it must outline the legal basis of the claim and demonstrate that the court has jurisdiction. So normally the application is it identifies the specific legal dispute, you cite the relevant treaty or custom or the principle being violated, and you establish the court's jurisdiction. This process can be seen primarily in MUN through memorial writing, which we shall discuss in our next class. And we have the advisory proceedings of the court, because we said the court has contentious jurisdiction and advisory jurisdiction. So for advisory proceedings, the ICJ, or rather, as we agreed, these are not instituted by states, but they're instituted by UN bodies, the organs of the UN, and specialized agencies. So a legal question is submitted to the court, and the court provides an advisory opinion. And these opinions are not binding, but they just carry authority. So for advisory proceedings, it's not one party versus another. It is a UN organ or a UN body or a specialized agency coming to the court and saying, hey, would like your take on this matter. There's this resolution on our table. Does this violate any law? How can we make this legal? How can we make this fair? How can we make this something that will be followed? So that's an advisory proceeding. And one of the most important people in the ICJ is the court's registrar. And I mean, once the court is filed, the court's registry, which is led by the registrar, plays an administrative role in managing the proceedings. So what are the roles of the registrar? The registrar receives and records applications. He notifies all the parties and UN members. He manages documentation and communication. And it is essential that all this happens so that the court can then run well. Meaning, the registrar is almost one of the most important people within the court. Any court, even national courts, have registries. This is where the cases are stored. This is where submissions are filed and they're stored as well. So the ICJ also has a registry, and they're the administrative role, or rather the administrative body within the court. So how do we move from a case being instituted to written proceedings? An application has been filed, either through unilateral application, or the both parties have agreed through a compromise that they accept the court's jurisdiction. So the court moves to the written phase. The written phase involves submission of detailed arguments known as memorials and counter memorials, which shall be our next class. But for the purposes of this class, we need to understand that once the application has been accepted, either through the compromise or the unilateral agreement, the court then moves to written submissions. And written submissions normally come before the oral submissions. So this is important as it forms the foundation of the legal arguments, and the quality of the written submission actually affects the quality of the case, meaning you need to have very good written submissions. Therefore, that is the importance of, or rather how the cases are brought, and its importance is to ensure that all delegates appreciate the procedural structure within international litigation, and it equips you with skills to participate in ICJ simulations, because now you can clearly establish the jurisdiction of the court in an application or in a memorial. You phrase the dispute in legal terms, you support claims with appropriate sources, and you anticipate and respond to jurisdictional challenges. Therefore, as we've said, we've done the application, we've brought the case before the court, and now we shall move into the written submissions, which shall be our next class. So see you in the next one.